Welcome to this episode of the Legal Paige podcast. So today I am going to be updating one of our episodes from the vault. That is episode 10, if you can believe it. And I really talked about in this episode, the big debate, independent contractors versus employees. And then recently, I've been having this discussion in the Legal Paige community on Facebook, and I recently had a very extensive talk about this on a Clubhouse room. And I knew I needed to update the episode and just kind of reprise it, explain it a little bit more in depth. And it's all about independent contractors and how you can really utilize independent contractors to your benefit as a business owner when you're starting out and starting to grow your team. But then how non-competes really play into this. And can you even have a non-compete agreement with a contractor? Drum roll, I'll get to that in this episode. And then how that works with employees and how you can go about adding in non-compete agreements with employees. So if you're not on Clubhouse and you kind of miss this chat, just go make sure you follow me. I'm the Legal Paige, Paige, on Clubhouse. So you can find me in any time that I'm popping into rooms. You can always get a notification. So I hope I see you in Clubhouse if you're not there already. But I'm super excited to get into this episode. It's going to be jam-packed, full of really good information all about growing your team. So let's do it. You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. So I am an attorney, but I am not your attorney. All legal information I talk about on this episode is intended for the masses and a large variety of different businesses. I am only your attorney when you hire me and we sign an engagement letter for me to work specifically on your legal issues. Please feel free to seek out another attorney in your hometown if you need specific legal advice or contact me for more information. Alrighty, here's the episode, friends. Okay, you guys know I'm going to be giving an update on kind of independent contractors versus employees, what's happening in today's world, things that have happened with the Biden administration, and things that have occurred in various states over the past year. So now to start out this episode, let's just talk about the difference between independent contractors and employees, okay? I just want to give you like the full picture here of what these two look like. The difference between them is all about control, how you control your worker. So by definition, independent contractors are independent. They should be able to dictate their schedules. That means that you, as their employer, cannot tell an independent contractor when to work unless you want to give that specific worker the benefits of being a true employee, i.e., you tell them, here is the project, here is what I need you to get done. If they're on like an hourly fee, then they can work as many hours as possible to finalize that project for you. Oftentimes, it's best to kind of pay per project in order for them to really be deemed a contractor. There are definitely scenarios where it's appropriate to pay independent contractors hourly, and I'll get into that here a little bit more in depth. But generally speaking, independent contractors do the job as they see fit. They do set their own hours. If they want to complete the project at 2 a.m. on their couch, they totally can. If they are morning people and they want to work at 5 a.m., that is not me. You guys all know that. I am a worker bee in the afternoons and evenings, but mornings are not my jam. But if they want to work in the mornings, that's fine. The main thing is you can't be like, oh, I only work 8 a.m. to 5 p.m. And so really that's the only time you can contact me. And that's really what I want when I want you to be working. You can't say that to a contractor. That makes them look extremely more like an employee in the eyes of the IRS. They also should primarily be paid by the project and not on an hourly basis. Not never on an hourly basis. And here's what I mean by that. Oftentimes you can have contractors that have their own business. They work for multiple different business owners. they're kind of like an added asset to your team for a particular purpose. Okay. Like my podcast manager, for example, is an independent contractor. She is paid hourly, but she designates her hours according to her own schedule every week. She has multiple podcasts that she works for and produces. She, contacts me whenever on Slack is, most efficient for her and suitable for her schedule. So we don't have like set hourly times where she is going to be working for the legal page. She does it by project, so by episode. And oftentimes some episodes take more time than others. So that's why we pay her hourly. But specifically, she is her own business owner. She is remote. She's using her own equipment. Everything that she has program-wise is on her computer. Her business pays for that. That is definitely going to look more like a contractor in the eyes of the IRS, even if they're paid hourly. So that's why I say not never on hourly basis. Oftentimes it's all about weighing the difference between the control. Remember back to what I said, the difference is all about control. How much are you controlling and how much are you not controlling? And where is that balance tipping in a contractor's favor or an employee's favor? So usually, again, contractors own their own business. If someone is basically not a W-2 employee working for someone else, they're not side hustling for you, they're primarily working for you 20, 30 hours a week, and you're trying to say that they're a contractor, that's going to be extremely difficult. And you could get the IRS knocking on your door later down the road saying, this person looks very much like an employee. So if they are primarily only working for you, they don't own their own business, they're kind of just this solo person that's working under their social security number, you have to be very careful there about the level of control that you give them and also about the level of education that you give them. So any type of training involved, telling them what to do, how to do it, the best way to do it for your business, that's going to look more like an employee as well. It's complicated, my friends. I totally understand that. So that's why I really just wanted to dig into some of those bigger questions that people were having on our Clubhouse room and also questions that we're constantly getting. There was this big string of independent contractor v. employee on the legal page community on Facebook, and people were talking about, okay, I do this, and they're a contractor. And I mean, I was thinking in my head, you're not checking a whole lot of boxes for contractors here. That looks like an employee to me. The main thing is contractors really don't have regular hours, okay? Sometimes you may have a completely remote team. That's totally fine in the online space. Maybe you have a check-in every week where it's a team meeting. That can honestly be okay as long as the majority of their hours, like 95 to 99% of their hours, are all kind of done on their own whenever they want to work. And especially if they're not working exclusively for you, if they're having team meetings with various clients that they're working for, just to like check in with all of the contractors probably that make up that other team, that's fine. It's 100% fine because essentially the contractor is agreeing to meet with the owner or meet with the team member at that specific time. Again, you just don't want to do that consistently where you're having a Monday meeting and a Wednesday meeting and a Friday meeting, and those meetings last for 2 hours. That's 6 hours out of their week. And again, you're really tipping the balance there in favor of them really being treated like an employee. You're telling them when to show up, what you're going to be talking about on that day, and basically telling them the hours that they're going to work. An employee, in turn, has a company that they work for. They have hours that they work. You can dictate a lot of what they do, how they work, the best way to go about that. You offer them education, training. Sometimes you offer them equipment and computers and programs, and you pay for a lot of their expenses when you travel, or just a lot of their expenses in general if it's business related whatsoever. An employee really is someone where they don't have their own business. They are not sending you invoices. That's a big one as well. Independent contractors oftentimes are sending the company invoices. I always suggest that you have your contractors do this. If you do want them to be an actual contractor, make sure they have their own business. they have multiple clients, they're sending you an invoice, because that is another added piece of evidence that shows they're really just invoicing me. I'm not like asking for their hours and then paying them like an employee kind of thing, like a W-2 employee. But for employees, oftentimes they're just reporting the hours that they worked, or they're on a salary, right? You've had them sign an employee agreement to that effect. And then the company is going to withhold income tax and your FICA taxes here. And every time I say FICA taxes, I'm like, oh, it's Rachel from Friends, where she's like, FICA? Who is that? Who's taking all my money? But that's Social Security, Medicare taxes, and you are taking that from the employee's wages, and then you're paying your share as their employer. But for an independent contractor, a company does not withhold taxes whatsoever. So if they are charging $25 an hour and they worked for you, say 12 hours, you're going to be paying them $300 flat. But for someone else that would be an employee, you're going to be putting on their payroll stub $300, and then you're going to be paying Social Security, Medicare, all of your income and employment taxes. They're going to be deducted from their pay every month, and then, or, every 2 weeks, however you do it. Oftentimes entrepreneurs online are basically running payroll monthly. It's just much more simple unless you have a lot of employees and it makes sense to do it every other week. But the business as well is going to have to pay your portion of taxes. So oftentimes, if you are hiring on employees, that's why people always say it is more expensive on behalf of the business, which is why as solopreneurs and people who are just starting to grow their teams, building it by contractors, it makes more sense financially and just legally speaking. It's a lot easier. You don't have to put them on payroll. You don't have to have unemployment insurance, workers' compensation insurance. You don't have to have all of these things for your employees. And really, you don't have to pay this added expense of their share of taxes and then, of course, running payroll. It can be oftentimes like 1.3 to like 1.6, I think, is about the average multiplier of their average pay. So if you're saying, okay, someone's going to be making $2,500 a month on salary as an employee working for me, that may work for you financially, but 2,500, remember, times that by about 1.5 so that you can ensure that that amount of money is available to you. Before you hire any employees, I always suggest that you have about 6 months in the bank of pay for them so that there's no financial burden on behalf of your business. It's not appropriate as a small business owner to just hire employees outright unless you have the legal and financial backing to be able to do so. And again, like I said here, employment and labor laws also apply to employees and not to independent contractors. So you do have to make sure that your workers are actually legitimately qualified as contractors. And if they're not, and you have to retract backwards and they do end up being qualified as employees, and you haven't done, proper unemployment insurance for them, or you haven't done something according to the labor laws of your state in compliance with having an employee on hand, or you violated some labor law for employees, like an employer to employee labor law, and then, they're retroactively deemed an employee and you had them as a contractor, that's no bueno. So don't do that, because it could get you not just fined with like the IRS and your state government, it can also get you in big hot trouble for employment labor laws in your state. All right, so I want to sum this all up for you in terms of independent contractors. Here are the things to look for to decide between the two. Work hours versus projects. Are they working on an hourly rate versus a project by project basis? If they're working on an hourly rate and you're still having them as contractors, that's okay as long as they're really only clocking hours related to specific projects and they're not just there to work a minimum of 20 hours a week and you're just throwing projects at them right and left. That looks more like an employee, okay? Who is providing the equipment? Equipment is part of this balancing act and control. If you're controlling what equipment they use, what programs they use, if you're paying for all of this, they're definitely looking more like an employee. But if they have their own setup, they're completely remote, they're using all their own equipment and all of their own gear, that's going to look definitely more like a contractor. Also, the definite nature of the relationship is something to consider that I haven't really talked about. That's definitely, though, one of the checkboxes that you need to look at. Are you just working with this person for a certain period of time? Is it a 3-month project? Is it a 6-month project? Is it on a month-to-month basis as well? Lots of times contractors are maybe they're 3 months to get started minimum, and then it goes month to month, and you sign an independent contractor agreement to that effect. That is going to definitely look like a very term-based relationship, and so that's more heavily favored in terms of an independent contractor, whereby an employee is probably there for an indefinite period of time or until you fire them. If that's pretty clear and they, assume that they're going to be working for you unless, something happens to your business or they do something wrong or there's a breakdown of communication or you let them go, then that's going to obviously be more like an employee. I talked about invoices here. Independent contractors are usually sending a full invoice for all of the projects that they worked on. Make sure they're defining the work that they're actually doing. So it's kind of project-based. And then they're invoicing you and sending an invoice on behalf of their business. If it's on behalf of their person, that can look a little more like an employee. So make sure that they're an actual business entity if they're a contractor and they're sending an invoice to you. Sometimes like sole proprietors or people who are just kind of side hustling, maybe they're virtual assistants and they're working for you on a contractor basis. This is where you probably are wanting to have a conversation with these type of contractors and say, I know it's probably, not the right time for you to become a limited liability company or working under a DBA business. I would definitely, though, appreciate if you would consider that, like filing a DBA in your state so that you're actually invoicing me through your business name and not your personal name. It will definitely ensure that our contractor relationship is all squared away and that you don't look so much like an employee. Oftentimes it's a really easy conversation to have with your workers because contractors more often than not don't really want to be employees. They don't want to succumb to all of the control that you would have over them if they are an employee. So it can just be an open conversation that you have with your workers. If you're like listening to this podcast and saying, Paige is telling me to get a few things squared away here so that my contractors look a lot more like contractors than they do right now. That's totally fine. You can just have that conversation with them. And I promise you, it's not going to be like, wait, am I supposed to be an employee? If you're worried about that, that probably means they probably should be an employee. A contract as well. That's another checkbox you got to consider. So are they sending you an independent contractor agreement or are you sending them an independent contractor agreement? In the eyes of like state government and IRS, it's always best legally for your contractor to be sending you a contract on behalf of their business. That obviously makes them look a lot more independent from you as a business owner. If you're sending them a contractor agreement, you just have to be careful there because that kind of looks like you're controlling the relationship a bit more. But if they're sending you an independent contractor agreement, I would always ask them for that too. Like, hey, do you have a contract that we could sign and negotiate and work on together? That is the best way to go here. And that's going to make them look more like a contractor. If they're signing an employment agreement, the answer there is they're an employee. And then one other thing that I just wanted to touch on here, the balance and control between contractor versus employee, is what are they performing services for? Is it kind of your core business services? Like, are they an OBM for your business, online business manager? Are they like running the entire extent of your operations of your business? Or are they doing one select little thing? Contractors should provide supplemental services like a podcast manager, or they're just running your inbox as a VA, or they're just doing like website design and development for you. That is going to look more like a contractor. If they are an integral part of your business, like I have a digital marketing manager here at the Legal Page, and they are working for me constantly on every aspect of my business, all in the back end operations, digital side, every content channel we have. They're so integral in my business that they have to be an employee, and they are an employee of the Legal Page. So that's something to consider as well. Like, what are they performing business-wise? Is it a core integral part of your business, or is it just supplemental? That'll help you weigh whether it's a contractor or an employee. Now, as I said previously, there's a lot of employment law differences. Employees are covered by a number of federal and state labor laws, whereas contractors are not covered by employment or labor laws whatsoever because they're a contractor. They're kind of like, they have to have their own insurance. They have to really cover their own patooties, right? So make sure that when you are hiring on contractors, one thing to consider is to ask them, do you have business insurance? Because if they don't, it's going to look like they want to fall under your business insurance. And I've seen that actually in the legal world before. I had a case in court that was kind of dealing with like a trucking company. And there was this is totally out in left field here, but I promise I'm going to bring it back around. The trucking company had a bunch of independent contractors that they deemed independent. They had their own semis and then they carried loads and the company just contracted with them. When instead they didn't have their own insurance, and the larger trucking company that hired these contracted truck drivers to drive for them had them under the umbrella of their own insurance. And that was basically what the court said kind of made them look like employees in full, is you were basically taking on all of the liability and risk and negligence that could occur from any of your contractors, i.e. any of your employees. And that's something to consider. So when you're hiring a contractor on, it's always best to ask them, do you have your own business insurance? Especially if they are their own business, they are their own LLC. Just do you have some general liability insurance? Because if they're a contractor, there may even be an exception in your business insurance policy that says it excludes contractors, general contractors. For all intensive purposes, this only covers all employees in your business. And usually you have to tell your insurance company for premium purposes how many employees you have, because that will obviously increase the risks associated with your business. And in that vein, employees get the rights, protections, and benefits of being one. And that's a big thing. That's the whole difference between what is a contractor and what is an employee. Employees get these rights and protections that they wouldn't otherwise because they are agreeing to work only for your business. They are kind of negotiating pay. They understand what they're getting into. They are refusing work elsewhere. And they basically are vested in your business. They're putting their best foot forward to work for you and benefit your company. And so they get some rights for doing that and protections of doing that. That includes vacation time, sick time, sharing of tax liability, like I was saying, with your W-2s and your payroll taxes every month or every payroll period. Wrongful termination as well. There's lots and lots and lots of employment laws on wrongful termination. Something you want to talk to your attorney about when you hire on employees is, hey, what is kind of my length of a probationary period with employees? In various states, your employees can be at will. Oftentimes, most states are at will employment, which means you can fire them at any time for any reason. But there's some states like Montana, where I live, where you can only have a very small period of a probationary period. Oftentimes it's about 6 months. It can be up to a year. It just has to be a reasonable period. If you define it differently under the contract, just basically default rules are 6 months under our employment laws in Montana. And then you can only fire them for cause. And so then they could sue for wrongful termination if you fire them for another reason. And so just make sure you're checking with your employee on wrongful termination laws, because again, when I was in court, some of the big employment cases I worked on were wrongful termination. They are going to come after you and your insurance company if you do something wrong. That is a huge protection of being an employee, is you should only be terminated for cause purposes. And then, of course, severance, overtime pay. There's a lot of different things to consider that you get the benefit of when you are an employee working for a company. And so as employers and small business owners, we need to be aware of those if we do ever have to let them go or furlough them, or you have to pay overtime because they aren't exempted from overtime in any capacity. They're on hourly rates, those things. I also talked about unemployment insurance. So business owners need to report state and federal unemployment insurance for employees, but business owners who hire contractors have no obligation to do so. Oh, hey, want to know what steps you need to take to ensure your business is legit and fully protected? If so, the good news is I've got a free guide just for you. This actionable step-by-step guide will give you all of the legally legit information you need to get your business legal and protected in no time. Again, this is a 10-step guide and it's completely free just for you tuning into this episode today. Just go to thelegalpaige.com/10 steps. That's thelegalpaige, PAIGE.com/10 steps. Now let's talk about agreements, because this is kind of where we went down a rabbit hole in the Clubhouse room. And the thing that I really wanted to chat about here was non-compete agreements and then the difference with that and NDAs. First, though, let's talk about agreements. Absolutely sign an independent contractor agreement with a contractor. If they don't have one, send one to them. It's best if they have one of their own, but you want to ensure that you have clauses related to them actually being 1099 employees, that all of the confidential information that they may acquire from working for your business is kept safe. What is the copyright ownership? It's probably a work made for hire situation, and so everything is automatically assigned to your business ownership for anything that they work on. Of course, fees, lay out the fee section, lay out that they have to send you invoices. That's all going to be in your contractor agreement. And then your employment agreement is going to be very similar to what we've all signed as W-2 employees before. That basically says like, yes, I agree to working for this company. Yes, so I agree to this pay. Yes, I understand that my payroll will be processed every 2 weeks, every month, so on and so forth. Whatever you send them with your W-4 and I-9 form, it will take out a certain portion of your taxes. They have to pay a certain portion of your employment and income taxes, employment taxes as well. But then contract-wise, non-compete. So a non-compete essentially restricts someone from working in competition with you or using anything that they learn from your business for their own business venture. Non-competes are not favored under the law. You don't ever want to have a contractor sign a non-compete. Like, I can just blanketly say here, if you're doing that, those people are going to look like employees and you're going to get dinged if you get audited. So don't do that. I cannot recommend it enough. Non-competes are really, I know it would be nice to do that for some, contractors that may work for you. I know in the photography world, this is talked about all the time. And my good friend and I in the industry were just texting back and forth the other day, and we were saying, we could go on a rant about this, on how really associate photographers that come onto your team, how associate photographers are actually treated extremely poorly in the industry, and how it's just like not a good setup for them, because there's like this misnomer in the industry that you can have associate photographers as contractors and basically restrict anything and everything they do for like their own business benefit. And if that were to get in front of a court, you'd be hard pressed. It'd be an uphill battle to say that they're not an employee. So I'm really trying to take charge here and lead the fight of associate photographers should really be employees if they're coming onto your business and you're restricting a bunch of things. And especially with a photography business, you're basically giving them all of your trade secrets and you're training them and you're telling them what to do, and they have to do everything according to your business standards. They have to shoot like you, you have to edit and cull like me. I mean, all these different things. You cannot slap a non-compete agreement on that unless they're an employee. So just don't do it. You might be able to have them sign an NDA, which means a non-disclosure agreement, so they can't disclose any of your trade secrets to a third party. That's okay, and that would be helpful for you to have a contractor sign an NDA in certain circumstances. That's basically just keeping all of your confidentialities in place for your business and ensuring that they don't divulge things and basically relay trade secrets to everyone or create a whole course using your trade secrets later on down the road. That's a big no-no. So they could sign an NDA for that. But a non-compete with a contractor, just don't do it, okay? Don't do it. So for second shooters that come and work for you on wedding days, which I often did and hired them out, they always had their own photography business. And I had non-solicitation clauses in my second shooter agreements with them. I wanted to make sure they were contractors, but I also wanted to make sure that if they did like connect with a bridesmaid at a wedding, or they became really good friends with the mother of the groom or something along those lines, that they weren't giving out their business information saying, hey, follow my business on Instagram and not the business that, they've actually hired to be there, my business. And of course, not giving out their own business cards. So I always have non-solicitation agreements. That's just a way to like say, when you're working for me, you're being hired to basically represent my brand at this thing using your own training and expertise and equipment and all of those things. But I just don't want you to solicit my clients. That's okay to have in a contractor agreement. But like I said, non-compete's a big no-no. Speaking of non-competes here in terms of employees, you also have to be very, very careful. So when you want to have an employee sign a non-compete, so you're like, okay, a big thing that I want is control over what they do within the next 2 years. If you're hiring an employee and one thing that's really important to you is controlling what they do with their life after leaving your business, i.e. implementing a non-compete that says you can't compete with my business, you can't open up a competing business or commercial enterprise that's basically in my vicinity and in my industry within a certain period of time after termination. That's essentially what a non-compete agreement does. Those have to be very, very, very narrow in scope. And judges are going to look at it in order to enforce a non-compete. They have to be specific, which is where I'm saying if that type of control is really important to you, work with an attorney to write your non-compete. You can always get non-compete templates, non-compete agreement templates online. We have them at the Legal Paige shop, and it's a great starting point. But the one thing to consider is that you're restricting the time period. It can't be indefinite. You can't say you can't compete for all eternity. Usually it's 2 years or less, and even 2 years is a lot of time. So 1 year would be great that they can't compete for 1 year with all of the knowledge that they gain from being an employee with your business. 2 years is probably max, but that's I'm just stating here like standard across the board for like an average amount of state laws. I don't know every single state law there ever was. And so there could be a new case that popped up in your state recently that said, no, we're going to make 18 months or we're going to make 12 months the limit here for non-competes. Only an attorney in your state would know that. So you got to check with them on that. So you want to limit the time period and you want to limit the industry so that they can compete in another industry that may be similar to yours, but is not in direct competition with you, right? Like maybe you're working hand in hand with clients. So if you're in the wedding industry and you're like a wedding planner, but then they decide to open up their own floral business, yes, that's kind of similar, but a judge is probably going to say that's really not competing with your business unless you're a planner / florist. That's different. But if they are like, oh, I've learned so much about planning, and as I've been doing that with your business, I've just learned that florals is where my heart is and I want to be a florist. That's fine. Like they're not violating a non-compete in that respect because they're not competing with you, even if you have the same clients or competing with a client's budget. You know what I mean? So non-competes have to be limited in time. They have to be limited in scope of the industry, and they have to be limited in location. So if they want to compete in another location outside a certain radius, that is fine. And that's interesting, right? Because a lot of us would want to restrict our non-competes to, say, our state. That usually does not fly in court. You can only have non-competes for like a locale, like within a 30, 60, 90 mile radius. Isn't that crazy? Under the law, they really want kind of free enterprise. You know, everyone can run their own businesses. Everyone has, their own, the makers of their own lives. Like you can't really restrict people's ability to do what they want to do and work how they want to work and own a business that they want to own, except for non-competes in a certain vicinity. And really, it's all about the quid pro quo here. How much did you give them? How much compensation did you give them? Did you give them enough compensation for this non-compete to be enforceable? if it was like minimum, like you were paying them like $30,000, $40,000 a year, and then you had them sign like the most strict lock and key non-compete, is not going to fly in court. Like you have to pay them a very substantial chunk of change for you to say that them signing on to not competing within my region, within my industry, and for a certain period of time after they are no longer with my business, you have to pay them a very considerable sum when they're working for you to have that non-compete essentially be agreeable and reasonable to a judge. And that's kind of the gist of non-competes, you guys. I could talk about non-competes for a long time. I am not a huge proponent of non-competes. The only time I would implement them is if you are doing so the right way with employees and you're taking like a template or a really general non-compete agreement and you're really making specific changes to that non-compete agreement in relation to your business and the employee that would work for you. And then again, make sure you have it checked over by a lawyer in your state, because state laws can be very, very different when it comes to non-competes. So non-competes are, they're available. They're out there. People do sign them. Businesses do have this, four-cornered document for employees to sign upon, becoming a part of their business. But the enforceability of non-competes is where things get sticky. So just be aware of an uphill battle that you may face, even if you do think you're super protected with a non-compete. Here are the 3 big questions that I want you to ask yourself. Does your business control the business aspects of the worker's job? This includes arrangements like how the worker is paid, whether expenses are reimbursed, who provides equipment, tools, and supplies. Ask also the question, does your business control or have the right to control what the worker does and how they do the job? That includes, of course, the hours that they work. If so, they're definitely headed more towards employee status. And then ask this question to yourself, is there a written contract? And is there any benefits associated with them working for you? If there's any type of like extra additional pay for vacations or sick time, a pension plan, insurance, anything along those lines that's covering your worker, that's going to be an employee. Overall, I really want you guys to take away the balancing act on the relationship as a whole between you and your worker after listening to this episode. How much control do you have over them? Are they checking those boxes of, independent contractor, employee? Are they having invoices? Are they working hourly or by project? How integral are they in your business? Are they sending you an independent contractor agreement? So on and so forth. I have a really, really great checklist for you, and we will link it in the show notes for this podcast episode. And it's going to be very beneficial for you to kind of look at it on paper and be able to check boxes in certain columns. And then the majority of your boxes, wherever they lie, will tell you whether you have a contractor or an employee. And if you're confused, okay, if you're sitting here being like, Paige, I really don't know the type of person that I hired. Please, please, please help. A few more points that I wanted to ensure that you have the knowledge on when considering how you're qualifying your workers is a major, major update since the Biden-Harris administration has come into office and what the Department of Labor has done federally with new standards for determining independent contractors versus employee statuses. So a ruling that was set to be effective as of March 2021 was, kind of what is an independent contractor, and they were trying to more heavily favor employees. But the Biden administration actually has frozen all regulations until they can be reviewed. So this new ruling, though, this, Department of Labor standards, when passed, is going to clarify the standard of, the new gig economy by establishing several tests. And here's where this comes from, is we all know under the AB5 law in California, if you haven't heard about it, I did a whole podcast episode on this. The AB5 law was this first big ruling and like standards set across the nation. And of course, California did this first because California always does things first with like employees and independent contractors. But lots of people go there to start their own businesses is why. And Silicon Valley and, all the other things. But again, California is always kind of the breeding ground for employment law and independent contractor standards, which I find really interesting because when AB5 came out, it was like January 1st, 2020 is when it went into effect. And essentially it said that if you meet all of these it's the ABC test. And if you meet all of these things, you can be a contractor. But if you don't, you're an employee. And it was actually kind of hard to meet if they didn't have their own business, if they weren't working in the same business as you, if they didn't have their own insurance, all of these different things, they were definitely an employee. And there was this uprising in the wedding industry in particular because we were hiring contractors left and right for certain gigs. And that's why I was saying like the gig worker bills are always changing by state and nationally because we want to have the free exercise of running your own business and working free exercise. But again, what this California law did, and I noted in basically everything that we put out with the legal page, I was saying, this is going to set a precedent and other states are going to follow suit. And that's what's happening federally as well. They're looking at how much the government is making off of, all of these employees and making sure that they're having employee rights taken care of and protecting employees and protecting the core workers of America. And that is what politics gets into. We all know that. But the two core factors that these new federal standards are probably going to take into account are the nature and degree of control over your work and your workers' opportunity for profit or loss. And this is oftentimes called the economic reality test as well, legally speaking. So if you want to go do a little bit more information on that, you definitely can. You can look at kind of some new Biden-Harris administration laws that are coming into effect for independent contractors and employees and what the administration is looking at now. That's obviously going to have an impact on the Federal Department of Labor with the new presidency. Things obviously changed during the Trump administration as well. So it's always good to keep on tap with what's happening now in our world, what is going on in our state and our federal government in terms of employment laws, and specifically, has anything been implemented recently in my state or my worker's state for independent contractor purposes. And that will help you lead you down the right path of ensuring that you are qualifying your worker correctly. So essentially, here's what happened for you. Regardless of what party you affiliate for, this is really important if you're in kind of the online space, independent contractor space. So the Trump administration intended to kind of have a big effect on the classification of workers as independent contractors. It was called this economic reality test to determine whether an individual would be considered to be in business for themselves or was economically dependent on the contracting entity for work. So there was two factors that focused on the question as to whether such a worker was in fact an employee: the nature and degree of control of the work and the worker's opportunity for profit or loss based on the initiative. So a lot of different people were kind of in favor of this because it really helped classify workers as contractors rather than full-time employees. And something that has been kind of at issue in the political realm is that a lot of politicians fail to realize that contracting, full-time or part-time, in my opinion as well, and probably many of you listening in, is that kind of independent contractor work provides vital life to our nation. And when you start implementing various regulations from new administrations that come into play, it really rocks the boat in terms of what's going to happen with qualifying people as contractors versus employees. And in the United States, we have millions of Americans. I think about 10% of the workforce, like 10 to 15 million people, are independent contractors. And that means they're their own bosses. They set their own hours. They're determining their own working standards and conditions. They may remain free to quit and resume work whenever they choose. And so when these type of labor laws change from administration to administration, it really changes the ability for Americans to work. And so when the Biden administration came in January, one of the first things they signed was kind of freezing the previous administration's rulemaking efforts on this law. And the Department of Labor had worked quite significantly to really clarify those differences between contractors and employees under federal labor law. And I think a lot of us in the online space were kind of looking forward to a federal rule coming out instead of it being so heavily based on state law. I'm excited to kind of see this play out and come into fruition. I've been watching it pretty closely with the Biden-Harris administration, but I don't know what's going to happen. It's all halted right now. I think they're going back to the drawing board. Politicians like to have their hands in a lot of things dealing with labor. But for all of us who are contractors, we do need to keep apprised of this situation. So feel free to dig into this a little bit more, read up on it, be aware of what's going on. And at this point in time, we don't have a huge worker classification rule, and we are hopefully going to soon. And when something like that comes out, you guys know I will do another episode specifically on that labor law to give you guys the 411 on what is on tap at that time. And that's it, my friends. Hopefully you got a lot out of that episode. I definitely had a good time recording this one. Independent contractors and employees is something that I consult on basically on the reg daily for my clients. And as they're building their teams, I'm constantly helping them consider what is going to be best in the long run for their business. What are their risks and loss associated with going a certain route and not going a certain route? And then they make the best decision for their business. I lay it all on the table for them. And that's what I hope you do here after this podcast episode. If you guys have further questions on this, you can definitely reach out to me. I'm at thelegalpage.com and the Legal Page basically everywhere else on social media. I hope you guys have a good one, and I'll see you again on the Legal Page podcast, same time, same place next week. Thanks so much for listening to this episode of the Legal Page podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpage.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.